Hello, I'm Judge Ann Segal, and you are currently appearing in the Pima County Justice Court. For some of you, this is your first appearance, and for some, it's your second. But nevertheless, it's important that you know what your rights are as well as your responsibilities are with respect to your criminal citation. If you're here for your criminal case and you have not signed in with the clerk, please sign in. Just because you're in the courtroom, it doesn't mean that we know that you're here. Now, you all are here because you have been charged with a criminal offense. Even if you received a paper citation, it nevertheless is still a criminal charge that is pending against you. Even if you thought you were not arrested, it is still, nevertheless, a criminal accusation that you face. So you have to understand what you need to do with respect to your case. If you are charged with a Class 3 misdemeanor, the maximum penalty that you face is a $500 fine and up to 1 year of probation. If you have a Class 2 misdemeanor, the maximum penalty you face is a $1,000 fine and up to 2 years of probation. If you have a Class 1 misdemeanor, the maximum penalty you face is up to a $2,500 fine and up to 3 years of probation. If you are charged with a DUI, or driving while you are impaired by drugs or alcohol, you face a maximum period of probation of up to 5 years. Those are the maximum penalties that we impose. I don't impose those penalties, but I'm required by law to tell you about those penalties so you are fully informed of your responsibilities. All the cases I've described to you also have a possibility of a jail sentence. You can be sentenced to jail if there is a mandatory jail sentence, such as for driving under the influence of alcohol, drugs, or in some circumstances, for altercations involving domestic violence. Sometimes you'll face a recommended jail sentence or a suspended jail sentence or supervised probation. That recommendation must be disclosed to you in advance by the county attorney's office. The judge must agree with that recommendation before it can be imposed. So as a whole, generally, jail is not a possible sentence that you face in the Pima County Justice Court. People will come to court and ask to have an attorney be appointed to represent them. However, an attorney is only appointed to represent you if there is a recommendation or mandatory jail sentence, or recommendation for supervised probation, or suspended jail sentence, and most importantly, you must financially qualify for court-appointed counsel. An attorney can be appointed to represent you if a judge finds that you may need an attorney in the interest of justice. But please understand that you can represent yourself, or you can always hire an attorney of your own choosing. Sometimes people will come to court and think, oh, I'll just talk to the judge, and the judge will have a common sense understanding of my case and dismiss it. Please understand that's not how the procedures work. The decision to prosecute any case is up to the county attorney's office. An assistant Pima County attorney may speak to you about your case. Please understand the Pima County attorney cannot give you legal advice. They're only explaining what the recommendation may be. There are also rights to the victim. If there is a victim present in court, please notify the clerk that you're here on behalf of a criminal case so that you can be acknowledged during the proceedings. The Pima County Attorney's Office generally will notify the victim that a defendant or a person accused of a criminal offense is scheduled to appear in court and that there are criminal charges pending against him or her. The victim is also usually given notice about any recommendation regarding reduced or dismissed charges. Sometimes a victim may have financial losses that must be repaid through restitution or as a condition of a sentence. Even if the victim in a case is a store or a casino or the government, your case will have to be reset for another court date to enable the Pima County Attorney's Office to give notice to the victim about their recommendations regarding the disposition of your case. When you appear in court, if there is not a victim involved in the case, your matter may be able to be resolved today. However, if there is a victim involved in this case, or if you wish to read the police report, your matter will be reset before this court or before a different judge. If your case is reset, you must come back to court. If you don't come back to court, it'll be a predictable result. a warrant can be issued for your arrest. Also, if you don't come back to court in Arizona, even for as much as a speeding ticket, your driver's license can be suspended. That means any car you drive, not just ones owned by you, can be impounded. So always remember that you must come back to court. Even if you disappear, your case does not. Again, with every criminal case, even if it may seem to be a minor one for you, you have particular rights. You have the right to hire an attorney of your own choosing, or you have the right to represent yourself if an attorney is not appointed to represent you. You have the right to have a different judge be assigned to your case. You have the right to have a trial. Now, if your case is set for a trial, it can proceed in your absence. It's one exception to a rule. If you are, however, found guilty, a warrant can be issued for your arrest for sentencing. You also have the right to remain silent at a trial and require the state to prove the charges against you with evidence that's convincing beyond a reasonable doubt. If it is your first time in court today, this is what's known as your arraignment. If you've come to court a second time or a third time, that is what is known as your case management. If there is no victim involved in your case and there's no police report, as your case may be resolved today. If there is a police report and you want to read it, or if there is a victim involved in your matter, your case will be reset for a second court date. Always remember to come back to court. At your next court date, or if this is your case management conference, you've been to court a second or third time, you or your attorney should receive a copy of the police report from the county attorney's office. The county attorney's office will disclose the names of witnesses and the information the county attorney's office has about the investigation of your case. The county attorney's office may give you a plea agreement with specific named penalties such as fines, counseling, community service. If you plead guilty to a charge in exchange for dismissed charges, you will enter into a plea agreement with the Pima County attorney's office. Please understand, however, the recommendations must be accepted by the judge for the plea agreement to be enforced. If you enter a plea of guilty, you will be asked questions by the judge. If you enter a plea of guilty, you must tell the judge what you did that resulted in your criminal charge. You can't tell the judge that you're really not guilty, but you just want to get it over with. If you plead guilty, you give up that right to a trial and you give up your right to an appeal. You have your right to have your sentence be reviewed for certain limited reasons, such as competency or for unfairness, but those are very limited reasons for which you could have your sentence be reviewed. Please understand that no personal questions will be asked about you, but all judges are required by law to tell you that if you're not a citizen of the United States, any conviction could affect your immigration or naturalization status. You could even be denied citizenship if you are convicted of a criminal offense. For some of you, you may read the police report and say, no, I'm not guilty. I do not believe I'm guilty. I do not believe the state can prove the charges against me with evidence that's convincing beyond a reasonable doubt. In that situation, your case will be reset oftentimes for a third court date for a trial. You are entitled to have a trial before a judge or a jury in certain types of cases such as DUI or common law offenses. The trials are usually set, as I said, at a third court date. At your trial, you have the right to confront and cross-examine witnesses who are called to testify against you. You have the right to have witnesses testify on your behalf. You have the right to remain silent and to require the state to prove the charges against you with evidence that's convincing beyond a reasonable doubt. Please understand, however, that you are not appointed an attorney to represent you because you've set the matter for trial. You will be given information about a trial setting to help you prepare for the trial. Please read the law. A judge cannot find you not guilty because it isn't fair that you got the citation or isn't fair about the penalty or sentencing that you're facing. Please understand, if you do not appear for the trial can proceed in your absence under our rules. But if you are found guilty, an arrest warrant will be issued for your sentence, and that can be ordered by the judge. Now, for those of you who make the decision that you want to enter a plea of guilty, or if you are found guilty after a trial, Please listen carefully to what the judge tells you that you need to do in order to understand the sentencing conditions that you face. You will receive a copy of your orders from the judge or the judge's clerk. This is known as a minute entry. Be sure you read the orders carefully before you leave the courtroom. Make sure there's no mistakes or confusion. If you need more information, the judge's clerk can also answer any questions you may have. Do not ever ignore orders of the court. If you are ordered not to contact the victim and you contact the victim, you can face additional criminal penalties or additional criminal charges. If you don't pay your fines in a timely way or ask for extensions of your time, your driver's license can be suspended. Your fines could be turned over to a collection agency for which you'll face additional interest rates and penalties. If you don't attend the counseling, community service projects, or educational courses that you are ordered to do so, you could face additional penalties or fines, or even be ordered to appear back in court to provide proof of that. And then if you don't appear again, your warrant could be issued for your arrest. Just by way of note though, if you're on metered parking and this matter is taking longer than you thought, go put money in your meter and come right back to court. We don't want you to get another ticket while you're waiting to take care of this one. For those of you who are here and have posted bond to be released from jail, or those who posted bond for an individual, please understand that bond can be held until all the court appearances are completed and all court orders are satisfied. Thank you very much for your patience in listening to this explanation of your rights and your responsibilities. When your name is called, if you're appearing before Judge Ann Segal, please come forward and be seated at the table that's marked defendant. Your case will be handled one at a time. Again, thank you for your time and courtesy.